The Child Care and Protection Act, Section 71, Constitution of Procedure in and Appeal from Children's Court, third schedule. Subsection 1. The minister responsible for justice shall cause to be established courts to be known as the Children's Court, which shall be constituted in accordance with the provisions of the third schedule, and when so constituted and sitting for the purpose of exercising any jurisdiction conferred by on them by this or any other enactment, shall be deemed to have, subject to the provisions of this act, all the powers of a resident magistrate court, and the procedure in the Children's Court, subject to the provisions of this act, shall be the same as in the resident magistrate court. Okay, so you have these courts, they call the Children's Court, right? And have all the powers of the resident magistrate court. They must be taken as seriously as a resident magistrate court. Their order are very much written in law, just as in any other court, such as a resident magistrate court. Right, subsection 2, the Governor General may appoint, in respect of each children's court, a clerk and deputy clerk who shall, in respect of the children's court, to which they are so appointed, have all powers and perform all duties which the clerk and deputy clerk have, and perform in respect of a resident magistrate court, provided that it shall be lawful for any clerk and deputy clerk, respectively, assigned under Section 7 of the Judicature Family Court Act, to exercise the like powers and perform the like duties as aforesaid in respect of the Children's Court, constituted by virtue of paragraph 4 of the third schedule. Subsection 3. Without prejudice to the power to bring before a children's court by any other means any child in need of care and protection, the attendance of a child or of any other person before a children's court, in accordance with the provisions of this act, may be enforced by the same officers, the same process, and in the same way as the attendance of persons before justices of the peace may be enforced under the provisions of the Justices of the Peace Jurisdiction Act. So, the summons to attend the children's court are just as strong as the summons to attend any other court. Subsection 4. Children's court shall sit as often as may be necessary for the purpose of exercising any jurisdiction conferred on them by or under this or any other enactment. Subsection 5. Subject to subsection 6. A children's court shall sit in such place or places as may from time to time be specified under paragraph 3 of the third schedule as the place or places in which the court shall sit. Subsection 6. Where no place is so specified, the children's court shall sit either in a different building or room from that in which the sittings of courts other than the children's court are held, or on different days or at different times from those on which sittings of such other courts are held. Subsection 7. No person shall be present at any sitting of a children's court except except members and officers of the court and any authorized person as defined in section 13. That's A. B. Parties to the case before the court, their attorneys at law, and witnesses giving or having given their evidence, and any other person directly concerned with the case. C. Bona fide representatives of newspapers or news agencies. D. Such other person as the court may specifically authorize to be present. So the children's court is not a court where any member of the public can just come in and sit. Right? And of course, this, I believe, is to protect the privacy of the children so that no unauthorized information may be released to the public about those children and the matters surrounding them, and so on. 8. Where a child is brought before a children's court, it shall be the duty of such court to explain to the child in as simple language as possible, A. the reason for the child being before the court, and B. that the child is entitled to the assistance of the children's advocate. Subsection 9. Where a child is charged before a children's court with any offense and does not have legal representation, the child shall act in accordance with sections 4.3. Section 4.3. This is section 4. No, this is section 1. Okay. Let me read there. We'll see what that is about. Subsection 10. Where a child is charged with any offense and admits the offense, or the court is satisfied that the offense has been proved, the child shall record a finding of that. The court shall record a finding of that offense, and before sentencing the child, shall obtain such information as to the child's general conduct, home surroundings, school record, and medical history, and may enable it to deal with the case in the best interests of the child. That's where the child confesses to the offense. Subsection 11. For the purpose of obtaining the information referred to in subsection 10, that's things like the school records, home surroundings, and medical records, right? For the purpose of obtaining the information referred to in subsection 10, or for special observation, the court may from time to time remand the child on bail or in custody. Subsection 12. An appeal shall lie from any decision of a children's court in the same manner and subject to the same procedure as an appeal from a resident magistrate's court.